Hello, this is Vin Bange from Taylor Wessing and welcome to our webinar today. Today's webinar is part of our regular webinar program where we bring you our expertise and views on topical data protection issues. Our regular attendees will be very familiar with our previous topics, which have included issues and subjects such as connected data, cookies, and online behavioral advertising, data security, mobile apps and privacy, and looking at other subjects that are very important to the data protection area, such as data transfers, cloud computing, big data, and of course, we revisited several subjects as those areas have been developing over time, not only in areas such as data transfers, but also the forthcoming EU data protection regulation. Recordings of those 30-plus webinars are still available if you missed them, and if you still wish to engage with us on those particular topics. Today, we will be looking at the topic of employees and data, your greatest asset or your weakest link. For those of you who are new to Taylor Wessing, new to our regular webinar program, welcome to you. As you will see from the slide deck and the slide in front of you right now, Taylor Wessing is a leading international law firm. We act for a range of leading clients in local and international markets, providing a full-service law firm offering from our office footprint, which spans across Northern, Central and Eastern Europe, the Middle East and Asia, and also more recently from our representative offices on the East and West Coast of America. And we've listed more details about the firm on the slide deck for your reference. Today's webinar is brought to you by Taylor Wessing's International Data Protection Practice. Our team advises on all aspects of data protection and information management law, and we do so from our office footprint, which is a global 22-partner-driven team, and also complemented by our international network of data privacy law specialists. At Taylor Wessing, we have a dedicated microsite specifically for all things data protection, and that's our global data hub. From this website and this very specific microsite, you'll be able to access news, which is updated weekly. And also, if you register, you'll receive a monthly mail shot of other updates and content as we upload that from time to time. You'll also see the topical issues that we will regularly look at, and these are issues that are raising concerns or challenges in the privacy arena in particular. You'll also be able to access webinars, so those 30-plus webinars that we already have broadcast. Those recordings you can access from the Global Data Hub, and also events from around the world and our practice globally, forthcoming and archived events are all accessible from the Global Data Hub. And also we feature international content and international coverage, such as our country pages, which are accessible from the drop-down menus on the Global Data Hub. So please do have a look at that if you've not had a look already. My name is Vin Bange, as I said, and I head the UK Data Protection Practice, and I'm based from our London office. Today we have a few members of the data protection team that will be presenting, given the range of issues that this particular topic raises, and I'm delighted to be joined by Paul Glass and also Stephanie Creed, and they're key members of our multidisciplinary data protection practice, and that'll be evident from the particular areas from today's subject that they will be covering. Their profile information is on the screen and within the slide deck for you to review at your own leisure. So in terms of what we're going to be covering today, in a moment I'll be handing over to Paul, who's going to start by looking at issues that are very relevant around misuse of data within the employment context. So looking at employee misuse of data and some of the very specific legal issues, as well as those points of experience that we have to share. And this is a very specific skill set that Paul brings to our particular practice. And then Stephanie's going to be taking a look at two particular areas of today's topic, and that's ensuring workplace compliance with data protection obligations, and also looking at issues around background checks and verification, which are quite important and integral to the employment context. And Stephanie, again, is not only a data protection specialist, but also an employment labor law specialist, so an incredibly useful and valuable skill set that we offer from our data protection practice. If you're a regular attendee, you'll be quite familiar with the polling questions that we will also visit towards the end of the webinar. And as is usual, and as was explained by the producer, when we get to that particular part of the presentation, there'll be 3 questions that we'll be polling your particular views on. So please do reply and submit your responses. Those responses are completely anonymized as far as presenting those results back today. And within a few months within a few moments of that polling closing, we'll be relaying those results back to you. So you'll get a view, an aggregated view of what your other fellow attendees will feedback on those particular questions. And also, if you have any questions as you go along, please do submit those questions using the webinar facility, and we will get to those questions at the end of the webinar as well. So without further ado, I will hand over to Paul Glass to look at the first part of today's webinar, Investigating Employee Misuse of Data. Paul.
Thank you, Vin. Turning quickly to the first slide, what I'm going to run through is just some of the issues which arise in relation to what's often referred to as the insider threats when it comes to data security, and just to draw out some of the points which come up when investigating potential insider threat and insider misuse of data. This is a topic in itself, really, which you could talk about for an hour or longer. So I'm just going to sort of skim through and highlight some of the key issues. Now, first point is insider risk. What do we actually mean by insider risk? It tends to get much less media coverage than major data breach incidents that we've seen recently, which are tended to be sort of external exfiltration of large volumes of data. I'm sure many of you are aware of the more recent incidents in relation to Anthem Healthcare in the US, for example, Sony, and the US government. But looking at the data on data threats, it's still the case that probably over 50%, depending on how you define an insider, probably more than 50% of breaches are actually based around an insider threat. So what do I mean by an insider? If you look at a narrow definition, it's current employees, contractors, anyone who works inside your business. Now, some commentators take a slightly wider view than that, and also include third-party service providers who may have access to some of your systems. So, outsourced IT function, for example, who need access to your IT systems or record keeping, or even ex-employees whose access may not have been properly terminated when they left the company. They haven't had their any remote logins terminated or passwords terminated, and so still have access to the system and can misuse your data via those routes. Now, why is investigating the insider threat, employee misuse, different from an external threat? A few sort of immediate reasons for that. Insiders tend to have a more detailed knowledge of systems than all but the most sophisticated external threats. And in addition to that, they'll have access to data as part of their jobs. Query how much data they should have access to, and as I'm sure many of you are aware, Edward Snowden's obviously the classic example now of somebody who had access to a little bit too much data, or rather somewhat more data than they should have done to actually do their job. It can often be easier for insiders to exfiltrate data, to actually take data out of the company. And as a classic example of that, we've seen numerous investigations into employee misuse of data where at the start of the investigation, unusual access patterns were visible, but it wasn't clear how, in fact, employees were getting data out of the business, and it turned out that it wasn't via IT systems. It was via mechanisms they could only utilize because they were employees. And finally, investigating insider activity can raise additional issues over investigating external threats. I'll speak about this in a little more detail in a moment, but for example, where you suspect or know that insiders are involved, you will need to keep under review when you're investigating whether anybody should be excluded from the investigation team because of potential involvement in the wrongdoing itself. So, turning briefly to the investigation, and I'm going to highlight some of the key issues here. When you become aware of a potential incident, drawing up an effective investigation plan right at the very start is essential. It allows you to consider the issues you need to deal with at the start. So you can work out what your legal issues are, what your internal goals are, how you want to deal with any compromise of data. And it allows you to plan the investigation, work out what evidence you think you need to gather, and to put yourself in the best position right at the very start to deal with what's the potential outcome of the investigation. So it could be potential litigation, it could be regulatory reporting or regulatory enforcement action, or it could be taking employment steps against employees who are involved in the wrongdoing. But having that investigation plan drawn up at the start is essential to being able to track the investigation through and make sure you're in as strong a position as you can be to take the next steps. Having said that, it's important to keep the plan under review. When you start out the investigation, you have a limited information set as to what's actually happened. So you do need to keep the investigation plan flexible and make sure that you do allow yourself to develop and amend the investigation plan as the investigation continues. A key point to flag at the start is legal privilege. And I've said on the slide here that in-house legal or external legal advisors should manage the investigation. The reason for this is that many investigations involving misuse of data will result in either actual legal proceedings or potential legal proceedings, be it to recover data, pursue action against third parties. You may end up in disputes with business partners who may be impacted by the loss, or you may end up having to report to regulators or deal with potential regulatory action. If in-house legal or external lawyers are involved in managing the investigation from the start, that puts you in the best position possible to be able to claim legal privilege in relation to work product and the running of the investigation and any final reports which are prepared. Now, you may, of course, decide down the line that you want to waive privilege in relation to, for example, the final report. But if privilege never existed, you've got no protection at all. At least if the investigation is run by either in-house or external legal, you have that capability to decide if you want to maintain privilege or waive it later on. It's key to decide who has overall oversight of the investigation at the start. And this is because you need to have clear reporting and decision-making lines as the investigation progresses, and also clear authority to take decisions. For example, if you need to decide whether to forensically image the work computers or work phones of employees who may be involved in the investigation, you need to have somebody who has the authority to make that decision and who is the ultimate arbiter, effectively, of whether you go down that route or not. Because you may need to make those decisions quite quickly. You may come into information which actually leads you to conclude that several other employees who you didn't know were involved in misuse of data are involved, and you may need to collect evidence from them very quickly. And it's important to have those clear decision-making and reporting lines set out at the very start of the investigation. It's important to be aware of where you might need external support and bring it in where necessary. The classic examples in relation to sort of investigations into misuse of data are forensic IT support, potentially forensic accountants, or other third-party service providers. Now, you may think, internal IT function, they can forensically image computers, they can deal with all of that. Now, potentially they can, but the forensic IT side is a different skill set from your typical IT support. And unless you have people within your IT function who have those specific skills and are aware of how to gather evidence to either a civil or potentially, if necessary, a criminal standard, you should consider whether to bring in external IT support. As I already highlighted, there's a good chance with misuse of data that either civil litigation, potentially even criminal action by regulators against wrongdoers, or simple reporting to regulators may follow, and in those situations you want to have collected evidence to the relevant standard to make sure that that will actually be usable in court. You need to consider who at the start is going to be involved in the investigation team. It's not uncommon in relation to misuse of data for example, somebody in an IT function to be involved in wrongdoing because they necessarily have access to wide amounts of data across the system, and they have the know-how to access the data and potentially also to cover their tracks in doing so. So there's a degree of it's an exercise in crystal ball gazing at the start because you only have a very small part of the picture. But you do need to consider, is it possible that, or is there evidence at this stage that certain people may be involved in the wrongdoing who might be involved in the investigation? If that is the case, you should consider whether to exclude them from the investigation team right from the start. The reasons for this are, firstly, their involvement in the investigation may enable them to destroy evidence or hide their activities as they see the investigation progressing. And secondly, privilege may be lost in investigation materials if, in fact, somebody involved in the investigation team is a wrongdoer and you are adverse to them later down the line if there are potential proceedings, either litigation or their employment is terminated. And the final point on the slide, and I'm only going to highlight this very quickly because it's a separate area all in itself, is if the investigation involves a whistleblower, then you do need to make sure that you have in place appropriate protections for that whistleblower as the investigation continues. And this has been a hot topic recently, which I'm sure many of you are aware of, as protection for whistleblowers has increased under English law in the last few years. So moving on to the investigation itself. As I alluded to earlier, getting the evidence gathering right is essential. Not only for the reasons I've already highlighted, so that you can demonstrate that evidence has been gathered in the right way and to the right standards, but getting evidence gathering right allows you to take the investigation as far as you can and, insofar as possible, actually get to the bottom of the wrongdoing in question rather than reaching a dead end. This has self-evidently a number of benefits. If you do decide you need to terminate employees or you need to take steps against third parties or make reports to regulators, you have the most evidence that you can. You're able to put yourself in the best position possible to take any of those steps. It also has an additional benefit for the business itself, which means that if you've obtained as much information as possible about the investigation, you're in the best position you can be to take remedial steps to your systems and controls and make repeat activity less likely or more difficult. One key area here is knowing in advance what your employment contracts do and don't allow you to do, and also knowing in advance what limitations there are, if any, under the relevant legislation with evidence gathering. And I'll just highlight very briefly here the fact that if an investigation crosses borders, you need to be aware of limitations in the other countries involved. For example, many civil law jurisdictions across Europe take very different approaches to gathering evidence in relation to employees to that within the UK. Now, it's common in the UK to have a term in employment contract that the product of any use of work email and work computers belong to the employer. Now, assuming you have an appropriate term in your employment contracts and appropriately worded, what this broadly means is that you will often be able to image computers and review the content of work email accounts, usually often without notifying the employee in question. And we've certainly seen situations where images have been taken of employees' computers overnight. So they've left work, everybody else has left work for the office, it's 8 o'clock in the evening, forensic IT consultants have then gone in, imaged the relevant computers, finished all their work, and are done by 5:30, 6 in the morning. They're out the door before any employees are back in the office. So we've obtained clean forensic images of the relevant computers without any of the potentially involved staff knowing. Now, broadly, if you can do this and have the appropriate terms in your employment contracts, it allows you to image the computers, it allows you to review the content of work email accounts. And this can be critical. You'd be amazed still how often people use work email to send incriminating emails in relation to wrongdoing or misuse of data. In addition to use of work email accounts, there are often useful traces left behind on work computers relating to the use of non-work email addresses on those computers. One point I've just alluded to with sort of imaging IT overnight is ensuring that you don't tip off suspected employees until you're ready to interview them. It can often be slightly difficult and can make the investigation take a slightly tortuous route if you do need to make sure that employees aren't aware of what's going on. But you need to make sure that you've gathered all the evidence and put yourself in the best position that you can before interviewing employees or suspects in an investigation. We've seen several situations where employees have started denying all knowledge of wrongdoing, but the information that we've gathered during the investigation so far, when it's put to them on a sort of drip-by-drip basis, demonstrating how each point they're making is wrong, often actually leads to an admission when employees realise that there is strong enough evidence to demonstrate that they were misusing data in some way. And the final point on the slide is just in relation to interviewing witnesses and suspects. There are a number of sort of HR issues which need to be dealt with in terms of giving appropriate notice of interviewing staff. You don't need to have a lawyer present, either in-house or external at an interview, but you should have an observer, in addition to the interviewer, who takes a very detailed note of the interviewer for further use. And you should also consider who is most likely to obtain a positive outcome for the interview. And this does involve considering the personalities of the people you're interviewing, what style of interview questioning they're most likely to respond well to. Interviews are an extension of any other evidence gathering, but you need to bear in mind the added human factor. And the final slide is dealing with regulators and action against employees and potentially also third parties. If a breach involves misuse of personal information, you may need to, well, there's no legal obligation to report to the ICO, but you should consider whether you do want to report to the Information Commissioner's Office or not. The approach the ICO takes is basically that if a breach is serious enough that the ICO think they should know about it, then they would expect to be reported. What is serious enough or not will depend on the volume and type of data compromised and the potential harm to data subjects. You also should consider whether there are any other relevant regulators. If your business is FCA regulated, then there may be reporting obligations in relation to data breaches if the breach indicates systems and controls failures. And reporting obligations to the FCA can arise from a number of different parts of CISC, so it's important to check carefully how the breach in question operates and whether you do in fact need to report to the FCA. Regulators, if you do report to them, will expect to be kept up to date on the investigation as it progresses. So you do need to keep that ongoing dialogue with the regulator. But you may think, well, why would I report early? Getting that dialogue going and showing to the regulator that you're taking the breach seriously is important and can actually improve your outcome if you show that you are doing a thorough investigation, keeping them updated, and making sure that you're not appearing to the regulator as though you're trying to hide the breach or the outcome of the investigation. It also means that you can put yourself in a better position for saying to the regulator how you're going to improve systems and controls to limit the risk of similar action in the future, because almost all regulators now take the approach of, if there has been an incident, even if they're not going to take enforcement action of any sort, they want to understand what you're doing to improve systems and controls to make sure it doesn't happen again in the future. One of the points on the slide is considering what steps to take against involved employees. There are sort of a range of options here on the employment side, also potential legal claims against involved employees. We should also consider if third parties external to the business are involved, whether you want to take action against those third parties. And that can include action steps to recover data or simply claims for damages. And there are a number of legal bases for doing that. Tort of deceit or fraud, breach of confidence, breach of data rights. There are a number of options which can be explored. And the final point on the slide there is considering what changes need to be made to employee education programs. And this is about taking the results of the investigation, applying them back into the business and considering how you need to educate employees and improve systems and processes. And as Stephanie is going to explain in more detail next, a culture of compliance and employee training are critical to putting in place and maintaining effective data security systems.
Thank you. So we're now going to have a look at creating a workplace culture of compliance. And the reason this is important is because data protection in the workplace is becoming an area of growing significance as collection, storage and processing of personal data is becoming increasingly integral to the operation of businesses as a whole. It's essential for businesses to ensure that their workforce operates in a way that complies with the UK data protection regime. And businesses, unfortunately, or fortunately, can't constantly scrutinise and watch over their employees and their actions. It's not feasible from a practical perspective, and it's not in the interests of efficiency, productivity, or creativity. So to remain compliant, one thing that you will need to do is create this workplace culture of data protection and security. That will be key. And in order to achieve this, you'll need a combination of training, support to staff, and implementing appropriate systems and security throughout the workplace. So looking just down the slide in front of you, you'll see sort of the 8 data protection principles set out. I'm not planning to focus on these, but they're just there as a reference. So some of the key considerations to take into account are looking at what your particular operational structure is and what steps you need to take in order to ensure sufficient compliance. Now, the data application protections are particularly key in relation to collecting, processing and storing of personal data. Higher obligations apply when dealing with sensitive personal information. Now, businesses may become involved in processing data in a wide variety of different situations, which could include dealing with customer or client data, handling data of other third parties such as contractors, suppliers and so on, processing personal data relating to staff members, benefits and payroll, for example, or internal HR and files and records, background checks, disciplinary records. It's important that businesses identify situations where they'll be processing personal data and appreciate the type of data being processed, because the nature of the applicable protection measures that should be implemented will vary accordingly. For example, HR departments dealing with personal data of workers will, in many cases, be processing sensitive personal data and consequently will probably have to take into account additional regulatory requirements. Where employees are working on contracts or projects that involve data processing of third-party information, such information may pose similar difficulties and higher obligations. Specific issues may also arise for larger or multinational businesses, particularly those with operations outside the EEA. Now, these organisations will need to consider potential restrictions on transfers of personal data, even within the same corporate group, if these cross into jurisdictions outside the European data protection regime. There may also need to be a need for additional storage and processing for the facilities within the relevant jurisdiction, as is likely to be the case in Russia, for example. Now, cloud storage also poses difficulties in terms of complying with data protection obligations, both in terms of security obligations and any jurisdictional requirements. And businesses and employees alike should be alive and alert to this issue with regard to this method of storage. Businesses which have either located or outsourced certain aspects of their operational structure to other jurisdictions, which includes often cloud storage arrangements, will need to ensure that their employees understand the applicable restrictions on transferring personal data to those regimes. Businesses will also need appropriate systems in place for regulating such transfers, and in the absence of such measures, staff may not fully appreciate the consequences of such transfers, particularly when in their own minds, transfers are effectively happening within the business itself. Coming on to sort of what you can do and kind of ways to approach this, one of the fundamental things you'll find is that training is key to building this culture of compliance. It's fundamental that the workforce understands the obligations regarding data protection and security for the business as well as for themselves as individuals. And at the heart of this will be the business's data protection policy. Now, these policies should act as a detailed guide explaining responsibilities both for the business and for individuals in a manner that's clear, concise, and easy to understand. Policies should be regularly reviewed and should be updated to ensure that they adequately reflect what is likely to be a continuously changing regulatory landscape. And as obvious as this may sound, it's also essential that employees actually read the policy. The phrase, colloquialism, you can lead a horse to water, but you can't make it drink, is pretty apt in this circumstance, because it's not just enough to have a policy. We all know, and we can all imagine circumstances where employees know this policy, don't really know what's in it, and haven't really paid much attention to it. And it's important that they understand and implement data protection policies. It's best that such policies are provided to any worker at the outset of their engagement, and good practice would be to ask employees to sign an acknowledgement that they've read and understood the policy and their obligations underneath it. Businesses should also be providing initial training to their workforce regarding specific data protection risks and obligations relevant to that business, and arranging for updates or refresher sessions where necessary. Now, given the particular considerations to be taken into account when dealing with personal data, and that may just vary depending on which part of the business a particular worker is in, businesses may also want to think about role-specific training in certain specialised areas, particularly, for example, HR. Training should be maintained and reinforced regularly, both to keep data protection at the forefront of employees' minds when working, and also to make sure that employees are aware of any developments within the law. Particularly where businesses routinely engage agency workers or independent contractors, which is very common in certain sectors, you should also be considering how to ensure that those independent contractors and so on are made aware and required to comply with businesses' data protection policy. Now, one way to do this would be to issue the policy routinely to any worker, irrespective of their status or label, and to require compliance with the policy. Any handbook should make clear that certain policies, including the data protection policy, will apply to independent contractors and so on, as well as employees, to avoid employment status issues which can cause concern. And again, good practice would be to ask workers to sign an acknowledgement that they have read and understood the policy and their obligations. Businesses should also consider making compliance with data protection obligations a term of any master services agreement, consultancy contract, or other relevant agreement. Another key element of the building your culture of compliance is your systems and security and what you have in place. Now, as part of your obligations under the DPA, businesses are required to ensure that any personal data which they are processing is protected by adequate security measures. Security measures include both digital and organisational systems designed to prevent breaches of security. In the case of data stored electronically, such measures will consist of having adequate firewalls, encryption, digital protection, both in relation to data stored on the business's internal hard drives or servers, and in relation to any file transfer or email facilities used. As regards internal storage, businesses should consider where data should be saved and stored. For example, will all computers and laptops be on a network? Will staff be encouraged to save all data to the network, or will they be permitted to save data to their personal drive or computer? And what are the associated risks for the business in doing so? Critically, staff should be ensured and should be made aware of the need to follow such security measures. In particular, businesses should make sure to their employees that the use of less secure file transfer facilities, such as Dropbox, Google Drive, and personal email accounts, may potentially put the security of that personal data at risk and therefore be in breach of the DPA obligations. Guidance on use of those systems should be reflected in the data protection policies mentioned earlier and provided in any initial systems training as well at the outset of engagements. Businesses should be considering implementing a standard document transfer procedure, including preferred file transfer sites, as this should reduce the likelihood of staff members using more risky methods of data storage and transfer. Particular consideration of these security obligations will be needed where businesses allow or require staff to use personal laptops and other bring-your-own devices when dealing with processing personal data. So businesses with home workers, flexible workers or remote workers are particularly at risk here, given there may be no home office or physical supervision, and you should be considering additional measures to comply with your data protection obligations. Businesses should identify the additional security risks involved and ensure that adequate security measures are in place for personal devices. You may want to consider providing for any remote access to company files to be restricted purely to online server access, or to the extent that that's not available, provide for remote hard drive deletion facilities where such devices are lost or stolen. At a basic level, employees should be required to keep data physically secure, so to keep any laptops or data documents in a secure location, not to leave the laptop or documents vulnerable to theft or distortion, and so on, and also to protect the data and its location with passwords and other appropriate security methods. In addition to any software-based security measures, you should also be ensuring that there are adequate and practical and organisational systems in place to provide security of personal data. Now, these organisational methods may involve appropriate reporting lines for data protection queries and also for suspected breaches. You may also find it useful to appoint a specific data protection officer within your organisation to deal with any such queries and manage communications with any regulators or the ICO. Now, businesses should also be considering, as a key point and something that Paul mentioned earlier, any powers they have to monitor employee activity in general, whether that's in employment contracts or in your data protection policies, and also any software and practical measures they can put in place in order to monitor and track the transfer and processing of data. Given the risks associated with breaches and the speed with which information could be transferred and disseminated, businesses should be considering any relevant measures for enforcing and evidencing breaches as well. So coming to a conclusion with a couple of final thoughts, creating a workplace culture of compliance is going to be key for any business in relation to both their data protection obligations and more broadly for their actual business. And there are a couple of key components to look at and consider when building and maintaining such a culture. You should be looking at the risks and requirements specific to your business, your sector and your clients, and developing a tailored data protection policy and system in order to best meet your needs and your obligations. So that's sort of looking at the creating a culture of workplace compliance for people already within your business. But another issue that comes up regularly with data protection is recruitment and how you find out about people without breaching your data protection obligations. So picture the scenario. Your company is hiring for a new position. You have interviewed several unsuitable candidates and you're starting to get a bit concerned, but then in walks the star applicant. It's a hallelujah moment. You're about to make an offer and then you start to wonder, is this really, are they really who they say they are? A bit too good to be true. If I just do a Google search, what's on their Facebook account? Now, determining whether a candidate will be a good fit for the company and are suitable for a role can be difficult. Employers usually want as much background information as possible about the applicant before making a job offer in order to make such an assessment. But what are the limitations and consequences of using background information that's readily available on social media sites, for example, during the recruitment process? Now, we've touched on already some of the data protection obligations, so I'm not going to go into detail on those again here. But the key point is that any obligations that apply to your employees you already have also will apply in respect of personal information that you collect during the recruitment process as much as that employer-employee relationship. So there will be consequences if you collect and use information about people as part of a recruitment or selection process. The label on employment status or relationship is to a certain extent irrelevant. Where personal data is collected, stored or processed, obligations under the DPA will apply and it will extend to current and former applicants. And that's for employees, agency workers, staff and even volunteers and work placement candidates. looking at it, the Act has basic principles which apply to processing of information. And processing is widely defined, but it will usually include obtaining, retention, use, access, disclosure and destruction of personal information. Since the recruitment process will undoubtedly involve some or all of that, you will need to be aware of your obligations and the steps you need to take in order to comply with your obligations. So turning generally to pre-employment checks and general principles, you should remember that information gathered, along with discussions about a candidate's suitability, so things like sending an email to someone, giving them a really blunt opinion of what you think of a candidate, can be the subject of a data subject access request. Now, this should cause employers to think twice when using social media or commenting on candidates, as you may not be comfortable disclosing that you've taken a quick look at Facebook, for example, and found something that you shouldn't have found, or commenting on information and or pictures that you've come across. Now, likewise, employers should consider what they, if they were in the candidate's shoes, might find acceptable in terms of background checks and searches. As a general rule, candidates are more understanding of criminal background checks, particularly where such checks are justified. They're much less understanding of searches of social media, because such sites and networks are commonly used in a personal, not professional capacity. In order to help employers comply with their obligations and to encourage good practice, the ICO has published a code that deals with the impact of data protection laws on the employment relationship and covers issues such as obtaining information about workers, retention and disclosure of records, and access to such records. There are extensive good practice recommendations in the code, and these cover a variety of different points of the recruitment process, including advertising the vacancy, handling of applications, shortlisting, interviews, pre-employment vetting and verification, and retention of recruitment records. So turning to look at some two of the key points, verification and vetting, what's the difference? Broadly speaking, verification is checking the details already provided by an applicant to ensure that such details are accurate and complete. So, for example, checking on qualifications or references listed on a CV. In contrast, vetting requires an employer to actively make their own independent inquiries from third parties about the applicant, and that's commonly things such as searching an applicant's social media profile or performing a criminal background check with the Disclosure and Barring Service, the DBS. So vetting is seen as a much more active and potentially intrusive step in the recruitment process. So with regard to vetting, could have a look at what is good practice. How do you stay on the right side of the line when it comes to vetting? You should only be vetting where there are particular and significant risks to the employer, to customers or clients or others, and where there is no less intrusive or reasonably practicable alternative. So one of the key things to remember is that you should be informing applicants ahead of any vetting taking place, that it will be taking place and what form it will take, whether it's social media checks, criminal history or whatever. Now this provides applicants with a chance to clean up their online profiles, or at the very least alter their privacy settings appropriately. It's often the very thing that prospective employers hope to catch, a warts and all snapshot of their potential employee recorded on their social media accounts. But perhaps because of the obvious differences in social media, so a LinkedIn profile commonly has a very different purpose to, say, a Facebook wall, and in line with the principle of freedom and protection in the UK data protection laws do protect employees to a certain extent from such intrusion. Vetting should be undertaken at as late a stage as practicable in the recruitment process, commonly only once an applicant has been shortlisted or conditionally appointed. Applicants should be given the opportunity to comment and make representations on the accuracy of their findings. If they're going to be damned on the basis of the picture from Ibiza 3 years ago, they need to know about it and be given a chance to actually say something about it. And this is intended to mitigate any risk that an employer relies on false information. Vetting should only be used as a means of obtaining specific information to fulfill clearly stated objectives. It's not meant to be a means of general intelligence gathering. In other words, you can't treat it as a fishing expedition. You should only be seeking information from reliable sources, where it's likely that relevant information about the applicant will be revealed, and any search should be proportionate in respect of the role. For example, the more senior and public-facing a role will be, the more detailed check will be required compared to more junior roles. So turning to look at some examples of where you'll find common searches for vetting. Sensitive and controversial searches, normally the most sensitive are online searches and social media checks. So looking at those first, the internet has opened a gateway for recruiters to search an applicant's online presence with relative ease and low cost, depending on how relaxed the applicant's privacy settings are. Social media sites such as Facebook, Twitter, LinkedIn, Instagram provide another avenue, easily accessed, for employers wanting to gain insight into an applicant beyond the image presented at the formal recruitment process. Employers should be routinely reminding themselves not to rely on information collected from possibly unreliable sources, and that's clearly the case with social media sites. Online profiles are not always created or controlled by the person they appear to refer to, which may or may not be in an applicant's control or with their consent. At a more innocent level, there may be other individuals who share the same name as an applicant and have social media accounts in that name. The key questions here to ask are, how sure can you be that a profile relates to the candidate you're considering, and how sure can you be that the social media account gives an accurate representation of that candidate? Now, the ICO has issued some warnings about ways that employers have tried to get this information. It's warned employers against using deception in order to gain access to applicants' social media profiles, or by attempting to friend the applicant and using a fake identity in the process. The ICO has also warned against employers asking applicants to provide their username and password in order to conduct a full review of their social media account. Now, while this is less common, employers have used this approach to incorrectly think they can sidestep risks in relation to accessing social media accounts. Don't be so quick to go down that route. It can get you into trouble. Now, aside from the potential to damage the employment relationship and mutual trust and confidence, which is a key part of that relationship, risky behaviour like that is likely to leave employers open to claims and liabilities as a consequence. From a practical perspective, it's likely to put off other candidates applying to your organisation, but also, in addition to potential data protection breaches, employers run the risk of obtaining information about protected characteristics, so information relating to age, for example, or sexual orientation, race. If a protected characteristic is found during the search, and an applicant subsequently claims that the decision not to hire them was based on one or more of those characteristics, it's a lot harder if you've carried out those searches to defend your position that it had nothing to do with the decision you made, and also then you would potentially have to disclose that information and the searches you've carried out. Applicants may argue that checking their online profiles constitutes a breach of their human rights. Should be noted that the Employment Appeal Tribunal has previously held that any information an employer puts on a social media site, for example, can't reasonably be considered to be part of their private life. So at the moment, such claims aren't likely to succeed. But as social media technology and the law evolve and lines between public and private become more blurred, this is likely to change. Now, looking at right to work and criminal background checks, whilst we're not going to look at this in too much detail, it's worth mentioning that you as an employer are not released from your data protection obligations in respect of such information simply because of its nature. All employees have to provide right to work and evidence of their right to work, and this is likely to be personal information. In addition, certain roles, such as those in the caring professions and dealing with vulnerable adults and children, may require employers to carry out criminal background checks. In such cases, requests for criminal history information should only be made to the DBS and only in respect of the applicant the employer intends to recruit. The underlying position is that you as an employer are not entitled to request information regarding criminal history without reason to do so, and you should only be requesting information on criminal history to the extent it can be justified for a role. As good practice, you should also be limiting the collection of information to offences that have a direct bearing on the role. So, for example, if a role contains financial responsibilities, you should only be limiting your searches to information on convictions for fraud, for example, or deception. You shouldn't be asking for spent convictions unless the job is covered by an exceptions order. So that's for people like medical practitioners, solicitors and accountants. That's because spent convictions are treated differently, and you should be aware that there may be additional sanctions under the Rehabilitation of Offenders Act, separate in addition to any data protection consequences. The other thing to note is that it is now a criminal offence for employers or prospective employers to force employees or applicants to obtain a copy of their criminal record by means of a subject access request and then to supply it to the employer or prospective employer in relation to their recruitment. And you also can't do this in relation to a precondition for providing services or goods. The point is that you should be carrying out any criminal records check through the DBS and only for specified purposes. The final type of check that comes up consistently are credit checks. And these aren't quite as common, but they do come up in respect of certain roles. And as with criminal background checks, the search should be proportionate. It's likely to be considered necessary and appropriate when you're dealing with an applicant who's applying for a senior role involving financial duties, so a financial director, for example, as opposed to a junior role or a role that doesn't have any financial responsibilities, plucking an example out of thin air, such as a graphic designer. So finally, just to round up, the position is really that employers face a difficult challenge of striking a balance between seeking information in order to hire the right candidates and their obligations under the DPA when seeking that information. The more information you have, the more informed your decision will be, but the greater the risk of your breach of your data protection obligations. So you should be focusing as an employer on the proportionality of any searches carried out, and you should be transparent with applicants in respect to the vetting and any searches to be carried out. Proportionality will differ on a case-by-case basis, largely depending on your business, the role and the responsibilities assigned to the role you're recruiting for. And as such, individuals in charge of the recruitment process should carefully think about what information they need, and in particular should think twice before Googling or going onto Facebook. Thanks.
Thank you very much, Stephanie. Thank you very much, Paul. We're just coming up to the tail end of the webinar now, and as usual, as I explained at the beginning, we're just going to send some polling questions before we take some actual questions that have also come in as well. So polling is now open. So please do click away and submit your responses. We've heard Paul talk about the internal threats, and our experience shows that at least 50% of breaches are due to an internal threat. So what I'd like to poll is whether from your organisation's actual or near misses, whether you agree with that figure, or whether you think it B higher or C lower. The second question we'd like to poll is more around the compliance aspects, which Steph talked about, and particularly the fundamental drivers around data protection compliance in the employment context, around effective policies and the robust requirements to have trackability, around rollout of policy in particular. So how sure are you that your employers are actually read the policies? As A, if you're sure they have, B, if you're unsure, or C, if you've never really taken those steps to obtain that particular assurance. And then the third question is more really around the emphasis on the internal threat which has been placed within your breach response and readiness plan. So again, I'd be interested in your views on that. And as we're waiting for the results to come through, we will be taking a break in August from our webinars, and we will be back in September, on the 22nd of September, where we will be recapping on the current overall data protection regime, so a bit of a primer. Before we embark into the webinars that will flow from that will focus in particular the changes that we're likely to see on the data protection regulation. The details of that will be released over the course of the next month and into September, so you'll have plenty of time to receive those information and register And if you're not actually registered on our Global Data Hub to receive those updates, please do take a moment to register on the Global Data Hub. So in terms of those particular polling questions, interesting. So on the first question, almost half of you agree that your experience is that 50% are due to the internal threats. That pretty much matches with the experience that we have advising some of the organisations that are participating on the call today and others on the breach incidents that we counsel and coach. In relation to the second question, how sure are you that employees have actually read the policies? Almost half of you are unsure that that is the case, and the rest of you are split between sure and have never taken those further steps. There's still a large proportion there that are unsure as to whether or not that is actually the case, and a further quarter there that is has never actually taken that step to verify that. So potentially a big compliance gap there from what we're seeing in that particular question. On the final one, in terms of the emphasis on the internal threat that's placed within your breach response and readiness plan, an interesting split here. Almost 38% of you think that you place sufficient emphasis, whilst the remainder of you will straddle either it's insufficient or, worryingly, over a third of you have said you've not verified it at this particular point in time. Given the changes that we're likely to be seeing in the forthcoming data protection regulation around breaches and breach response and the timeframes around that, as well as compliance requirements around how well prepared you are, readiness and preparation for breaches will become far more important, not simply because they are important to be able to handle a breach, but also because it will be a fundamental compliance requirement to be in that position of readiness. So again, the vast majority of you seem to have some work to do in that regard. So I know we're coming up to the end of the allotted hour, but I'm just going to ask Paul to comment on a couple of questions that have come in particular. Very quickly looking at these points. So the first question, Paul, that's come in, is it advisable to have a set process policy in place for any such breach events that you mentioned in your report?
Just differentiating slightly between what Vin was just referring to as sort of an incident response plan and an investigation plan itself. Certainly absolutely advisable and will become a requirement with the General Data Protection Regulation to have sort of an incident response plan in place. I think that's a slightly different thing to an actual investigation plan. And I think you can certainly have a template for an investigation plan, and you can highlight some of the issues in advance. For example, what do my employment contracts and what does the law allow me to do in relation to evidence gathering, and what is my reporting and decision-making process going to be. But it is important to put together an actual investigation plan for each incident that you do need to investigate, not least because they're all different. They all do raise, to some extent, different issues. You can prepare for some of the common issues which arise across many incidents, but I wouldn't say that it's necessary that you should have anything beyond sort of a template and an issues document forming part of your incident response plan to ensure that you do have the flexibility to deal with an incident and investigate an incident appropriately.
Thank you, Paul. And just time for one more of the questions that we've come in. And I think this really focuses on the privilege point that you mentioned. Would an in-house data protection practitioner rather than a lawyer be covered by legal privilege?
I'm afraid the answer to this one is no. We actually went to the Supreme Court last year in relation to the scope of legal privilege. Accountants were arguing that they should, in effect, be covered by privilege or something akin to privilege. The Supreme Court decided on that no privilege should not be extended beyond lawyers. So legal privilege extends to lawyers acting in their capacity as legal advisors. So even a lawyer who is advising on a commercial matter will not necessarily attract legal privilege. So it wouldn't attract, privilege wouldn't attract to an in-house data protection practitioner either.
Okay, thank you very much for that. Conscious that we've got one or two other questions, but we are running out of time. So those of you who sent questions that we haven't answered, we will get back to you directly and give you those views in relation to those questions. Thank you very much for those questions. Just a final word, as I mentioned a few moments ago, we're planning the webinar series for the autumn term, as it were, and also a series of breakfast briefings, which will start from September. So do stay in touch with us and our global data updates. And if you're not registered, please do, or contact one of us, and we'll make sure you will receive those particular updates. Also, in relation to the content that we've actually covered today, we've published written content around the topics discussed. So again, you'll find that on the Global Data Hub. And on some of the other areas that we've covered within the presentation, for example, more deeply into data breaches or data exports, the nature of policies, we have whole webinars and topic areas on those particular points that are still accessible on the Global Data Hub. So a lot of content that's there for you to access at your own leisure. So thank you very much for joining us today, and from the team here, thank you and goodbye.